The interesting thing about this case is that the ruling here is different than what we've been seeing recently, where much attention has been paid to the fact that the Obama board had found class action waivers and arbitration agreements to be overbroad and invalid, which is and was a very extreme view, which will be heard later by the Supreme Court. The issue here, though, is much simpler. It is that the arbitration agreement is focused on any and all claims that an employee may bring, and could be read to imply that an employee can't file a charge with the NLRB or bring an action before the EEOC. And it's that fact that this particular arbitration agreement didn't provide a carve out for those types of government agency actions that the board found to be invalid. The board in this case found that telling an employee that they're not allowed to talk about their suspension or their discipline and that they must keep that fact confidential to be a violation of the National Labor Relations Act. This in no way at all is new ground. And while it can be confused with some recent more controversial rulings by the NLRB under the Obama administration, where it was found that asking an employee not to talk about an HR investigation for confidentiality purposes could be unlawful. This case didn't go there. In fact, the problem here was very basic, that the HR person in the issue just made a mistake and told the employee, don't talk about your discipline. That's something employees have always had the right to do. I think the Dish Network case reminds employers to really look at their arbitration agreements and other HR policies and practices, not just in a light of the recent more controversial issues related to class action waivers or HR investigations, but they need to have experienced labor counsel guiding them through the core tenets of the National Labor Relations Act. And that, of course, includes making sure that their arbitration agreements cannot be read to in a way that would prohibit an employee from bringing a charge before the NLRB or from bringing some other government action, and that all of their HR policies, including their arbitration agreements, are read in light of the not only the evolving NLRB standards, but really the core ones that have been there for some time as well.